So the next slide will be the probation period. So if you want to offer someone an indefinite contract straight away, that is certainly possible. In that situation, we would really recommend to have the longest probation period possible, which is 2 months in the contract. Because you can see under the second one, probation period of 1 month is only possible if the contract is more than 6 months. 2 months would be from 24 months and longer or indefinite. And this is 6 months, more than 6 months. So if you give a contract of 6 months, you cannot add a probation period. So it needs to be 6 months and 1 day. That is a little bit not showing very much confidence in your employee, but usually employers tend to give a contract of 7 months and have that 7th month or the first month considered to be the probation period. And a probation period, why would you want that? It is to check if you are a good match with the employee, and also for the employee to check if the company is a good match with them, because you never know. And you have this whole recruitment process, but the moment someone starts to work, it could be different. Probation period, as mentioned before, needs to be in writing in the employment contract. If it's not in writing, it's void. If it is in writing, but it's the wrong duration, it's void as well. So if you include a probation period of 2 months in a 7-month contract, it's not that you can say, well, let's have then a probation period of 1 month. Sorry, my fault. No, the whole probation period is not valid. So please really be careful and just look at this sheet when you draft your contract or ask our advice. And both parties can invoke it. So if the employee is not happy in the position, they can also resign. And the resignation or the termination from the company side is per immediate. So it can just be any day within that month or within those 2 months, and the contract will end immediately. Of course, the employee will have a right to salary up to that point, but from then on, parties are released from each other. Yes, the last point is in the second bullet. The resignation or the termination can be done verbally, but also here again, we really strongly advise to have it in writing, an email, just confirming that the contract has come to an end. Because especially if an employee resigns, it could be in the heat of the moment, they might have had a bad day, they might have, it doesn't matter, they could say, I'm resigning, and the next day they're coming back, hi, I'm back. So if you have something in writing saying, hereby we confirm your resignation, and we're going to send a settlement agreement or financial settlement at the end, then you have something in place to prove it. And the probation period can also be included in a renewal contract. So you have your first contract, but if the second contract, or the third contract even, is more than 6 months, another probation period can be included, but only in the event that the employee is going to have a different position within the company. Because you know the person, you know if the person matches the company, but what you don't know if this person is going to do well in this new position. So it does give you a chance to include another probation period, but it really needs to be a distinctively different position, of course. Otherwise, it would be a means of terminating someone's contract too soon.